Welcome to While You Can, Adventures in Life and Legacy Planning.
Hello and welcome to While You Can, Adventures in Life and Legacy Planning with Amy Reagan. Amy is an estate and succession planning attorney based in Tampa Bay who serves clients all across Florida. A former big law litigator with an advanced tax law degree, Amy now helps professionals, real estate owners, and business leaders design customized plans for death, incapacity, and business succession. My name is Kevin Rosenquist, and today we're kicking off the show with Amy's story from her high-stakes litigation background to her mission of making estate planning personal, practical, and empowering. Amy, welcome to the show.
Thank you. Good to see you, Kevin.
Yeah, I'm excited to learn about your background. You've been involved in some high-stakes cases at a global law firm. What inspired you to pivot from that litigation side to the estate and succession planning?
Yeah, to put it simply, litigation is a very reactive side of the law, and estate planning is more proactive. My personality type tends to be more towards being proactive rather than slinging mud in a court case, but I went to law school with the mindset to do something proactive. Some of my favorite subjects in law school were real estate transactions, income taxation, and corporate finance.
Most people run away from those things, so it's good to have people like you willing to do that.
Yeah, I think it's a running joke that lawyers just hate math. So, but not me.
Not you.
No. So, I went to law school in 2008 during the Great Recession, and it was a very legal, competitive market. And I went where the opportunities were during that time. And I'm very actually grateful for the experience that I ultimately gained, learning litigation skills, being exposed to government enforcement actions, and helping large international companies face those challenges head on. I was with the U.S. Attorney's Office as an extern my first year of law school. My second year, I had an opportunity to join a really large global firm, DLA Piper, in their disputes and litigation practice group. And fast forward 10 years, it was the pandemic. International travel had come to a sudden halt, seemingly overnight. And I started focusing more on domestic government enforcement actions, such as disputes opposite the IRS. I was helping individuals such as hedge fund managers, as well as companies that were preparing to sell, and something came up during their due diligence process. So I helped taxpayers get into compliance with the IRS, clear up issues where there was alleged non-compliance when in fact the taxpayer had been compliant. And a lot of these were very high stakes matters. And I have no regrets on my journey, but it really helped me take stock of where do I want to be. Ultimately, I was a senior attorney in the firm's tax group when I left and gave my resignation in 2023. I then started my own firm, focusing on the proactive side of law, helping a broader array of clients with proactive planning, keeping the government, keeping the courts out of their lives through proactive planning. It really became a mission to me, especially when I heard the statistic that's often cited in retirement magazines and articles about how nearly 70% of of adults in the US do not have a basic estate plan. Even if that number is smaller, say 50%, it's still staggering in terms of the number of individuals that are leaving it up to government statutes or leaving it up to their families to sort it out in court after they pass away or fall seriously ill. So it's really invigorating to me to be able to make a difference every single day that I'm working. So I formed my firm, A.E. Reagan Life and Legacy Planning, to carry out that mission.
Why do you think so few people have an estate plan? Any thoughts on that?
I haven't studied all the reasons, but if I had to guess, I think the reasoning probably varies. It's easy to overlook how important estate planning is.
Right.
It's easy to overlook, our own mortality and possibilities of falling seriously ill. And maybe folks just don't understand the options that are available to them. They might think of estate planning as just for the elderly, the medically frail, or for the ultra wealthy. Mm-hmm. And it really is for all of us. You should be taking action and proactive planning while you can. If you don't, you're just rolling the dice that you are putting it off for another day. Tomorrow may come, but we might not still be here and might not be in a position to sign a legally binding document. So it's better to take action today.
Yeah, to your point too, I think a lot of people do think it's for more wealthy people, especially just the name itself, estate planning. Like, I don't have an estate, right? Most people don't have what they would consider to be an estate, but maybe it's partially also the definition of the word that could be tripping people up as well.
Yeah.
So, all right. So that 70% number, you said your mission is to change that staggering statistic. So, the reasoning varies. We went there, but what else could?
There's a couple other reasons why somebody might be hesitant, not just because they think it's not for them, it's for someone else. I really don't think it's all that time consuming. It really doesn't have to become a full-time job or even part-time job for the client. Even the most sophisticated advanced planning, it might take your advisors, such as an attorney and a CPA and financial advisors, a couple months to finalize your plan, but that's not you working day in and day out. That's your advisors. But right. In cost could be another reason why someone might be hesitant, thinking that it's a very expensive endeavor that is not really, there's not a tangible object that they hold in their hand, but for documents that are stored in a safe place afterward. But it really is about that peace of mind that you get, knowing that your wishes are going to be met, that they're at least clearly communicated in a legally enforceable document, and that you're really taking the time to put a meaningful, thoughtful plan together rather than scrambling while facing something urgent and ultra challenging, like a sudden cancer diagnosis, a severe injury, failing to have a power of attorney in place. There's a lot of things that can suddenly become urgent, and you may or may not have capacity when these things arise. Also, sudden death, it can happen. It's not just the elderly that die. So once we have an accurate picture of what a client's goals, concerns, and circumstances are, what asset types they have, we can provide them with a number of options that will help them accomplish their goal in a cost-efficient manner that is tailored to their budget and needs.
Yeah, and to your point earlier, proactive versus reactive. People aren't probably real inherently proactive in a lot of ways. So that makes a lot of sense as to why people might do that. At your firm, you help everyone from young professionals to business owners. Do you tailor plans to match different life stages and goals? How does that all work?
Sure. So first and foremost, we don't just talk at clients and say, here's a one size fits all, sign your name here. It's really a straightforward and simple approach. We listen. I listen to clients. I help understand what it is they're trying to accomplish, what brought them to me on that day, what is it that's weighing on them, or is it simply they want to be proactive and they want to avoid having to make an urgent rush decision, or maybe not even have the opportunity in the future to make a plan. So what we do is we understand what they're trying to achieve, what their goals are, what their concerns are. And then we formulate a plan and provide options that address each of those. And for example, a plan for a brand new family, they might not have a lot of assets, but they do have loved ones to protect. their plan is going to look specific to that family and their circumstances and is likely to develop over time. For example, you're not going to name your 6-year-old son to be your durable power of attorney agent. First of all, that wouldn't be legally enforceable, but second of all, you don't want them making your decisions. But fast forward years down the road, you have adult children who are responsible, and you might want them to be a backup to your spouse, who you might have as your first agent to act for you if you couldn't. And then assets change over time as well. So we formulate a plan. We try to future-proof it as best we can. I think a good rule of thumb is very thoughtfully evaluating your plan every 5 years at a minimum. I also like to say it's good to have birthdays. And on your birthday is also a nice annual reminder to say, hey, if I didn't make it to my next birthday, is my plan in place? Are my beneficiaries up to date on my accounts? Do my loved ones know where my important documents are and what they would need to access swiftly to care for me or to handle my arrangements? So just simply put, it depends on the client. That growing family I was mentioning a minute ago, their plan is going to be potentially very different than someone who's further along in their life. They might have a variety of different interests and businesses. They might have an existing plan that they come to me with, perhaps an irrevocable or multiple irrevocable trusts that were created in the 90s. Several laws have changed since then. Even the best laid plans in the 90s couldn't have anticipated potentially where our tax exemptions are for estate and gift tax planning, for example. So we really just need to focus on what is important to the client, what their options are, and then we work with them to design something that makes sense for them. And I view myself as the person bringing the toolkit to the table, and they give me the other information. We listen, we sort through. Some of these decisions can be very hard, picking who's going to get what, who's going to have an important role in your estate plan, and a variety of different roles exist. Some are focused on finances, some are focused on healthcare, and you might want a daughter, a very responsible daughter who is a nurse or a doctor, to be in one of those medical roles, but you might not want to burden her with certain financial decisions if she has a very time-intensive job. You might select someone else for that role. But these are things that can be sorted out and formulated in a way that makes sense for the particular client.
Yeah, that totally makes sense. And you've compared planning to building a sturdy house with legal documents forming that foundation. Can you explain what that means and why you think it's so important to start with the basics?
Sure. So there are basics, and really, keeping with the tool and building analogies, you don't need a sledgehammer to push in a tack. And in fact, you could maybe do more damage if you did. So it's another just good analogy to remember. It's not a one size fits all, but there are some basics that many adults in Florida should have. At a minimum, most people have heard of a will. They kind of know what that means. There's some myths and misconceptions about what wills are and what they do or don't do. For example, some folks think that if you have a will, then your executor, personal representative that you select can just divvy up your assets with no need for the court. In Florida, that is not the case. You still file the original if it exists with the court, and you work through that probate process with the court. Another document is a living will, and this is while you're alive but incapacitated, in an end stage condition. At least 2 physicians have said that there's no reasonable medical probability of you recovering from such condition. It's an extremely narrow set of circumstances, and it's essentially where you're just being kept alive by machines is a good way to think about when would your living will come into place. So you're selecting potentially in your tailored living will to say, I don't want to be just a vegetable and kept alive artificially by machines, but I also don't want to be in unnecessary pain. So go ahead and make sure that I have comfort, but I don't want to unnecessarily prolong my life if it's in that status. And then you select in that very important document who you would want to be your advocate in your stead, because you're not able to advocate for yourself. Another similar but much broader document is the healthcare surrogate designation. These are individuals you're selecting, usually one at a time, to serve. You select one or two backups because you never know what we are doing. Proactive planning. We're planning for life's what ifs. So we're selecting someone to advocate, help you with your medical decisions if you're unable to, someone to be able to have access to you and to your medical information. It can also be selected to be immediately effective, meaning that you're selecting whoever it is to be your surrogate, that they will have immediate access to your information or to assist you with doctors' decisions. This is not a document, though, that takes away your rights and lets somebody else override your medical care. In fact, my documents say very clearly that even if you verbally indicate that you're revoking it, as long as you have capacity, legal capacity, you can do that. And no one's going to do anything against your will while you are alive and well. A fourth document that is extremely important and very common, and a lot of folks have heard about this document, it's a durable power of attorney. You are the principal when you create this document. That's your title. And the person that you're selecting is either your often referred to as your agent, or some people say attorney in fact. Even if they've never gone to law school, they're not a practicing lawyer, you're giving them that power to be your agent. And it's parallel power to you. It takes effect when you sign the document. Again, you want to select people you trust, but nobody's taking away your power. They're acting as a fiduciary in your interests, and they're stepping into your shoes and can pretty much do all the things that you would normally have power to do. But there are some limitations. So, for example, they cannot vote in an election for you. They cannot make or revise a will for you. They also cannot create an affidavit based on your personal knowledge. So Kevin sees someone run a red light, and your agent, who was not even in town when that happened, cannot sign an affidavit saying so-and-so ran a red light on such and such date. That isn't something that they could do for you. Another limitation, if you will, is if Kevin had a personal services contract to perform something for someone, the agent doesn't step in your shoes with respect to performing that contract on your behalf. So while it's an extremely broad document and the Florida legislature takes it very seriously and requires not just that you sign it, you can have witnessed and notarized and all that, there's still paragraphs that if that agent is to have those specific powers, you still have to initial right next to that paragraph. Some examples are HIPAA information, or modifying and creating a trust, as well as engaging in some other planning with assets or gifting assets on your behalf. And then finally, I would say a pre-need guardian declaration is a very fundamental document, but it is one of last resort, okay? Because a guardian is appointed by a court. And what this document does is say, if I'm ever in the situation where I need a court to appoint a guardian over my person or my property, this is the person that I want to be appointed. And if they're unable or unwilling or unavailable, this is a backup. and we at least have one backup when we create that document. It's given to the court in advance. It's a pre-need document, though. It's not like somebody's being immediately selected as your guardian. So those are the 5 fundamentals that I would say that most adults in the state of Florida should have.
All right. Well, that's great information for sure. We have lots more information coming your way from Amy. So that's it for our first episode of While You Can, Adventures in Life and Legacy Planning. If you're ready to start your own legacy planning journey in Florida, visit aereagan.com to book your consultation or to get a referral to a professional in your state. Don't forget to leave us a review. Subscribe to our channel. Again, we've got a ton more stuff coming your way. We're excited to bring it to you. Amy, I'm excited to keep talking to you. Thanks so much for your time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.